This is Michael Popok, and it's time for Legal AF After Dark. Donald Trump just had a closing argument to round out 11 weeks of trial in the New York civil fraud case. And even though the judge told Donald Trump that he should not present any kind of closing argument unless he agreed to the ground rules, of course, Trump being Trump and trying to do maximum collateral damage, jumped up at the end of the closing argument to attack the judge and the New York Attorney General. Have I whetted your appetite to hear more about the civil fraud case and where we think it's going? One place only, Legal AF on the MeidasTouch network. Take a listen to our most recent clip.
Is Alina Habba, Donald Trump, during their closing arguments before the New York Attorney General and the New York Attorney General civil fraud case. Justice Goron, of course, is the judge presiding over this matter. It was an 11-week, 44 days of trial, but really 3 years when you include the investigation itself that led to the lawsuit that was filed back in late September of 2022. That brought us to this moment. And that's why covering this every step of the way, Michael Popok, to get to that closing argument and then to get to that judgment that Justice Goron has promised that will likely take place before January 31st. I think it shows everybody out there how the law works. If you've been following Legal AF in this network from the outset, we've been going through every single step of this proceeding. And the last step, of course, is this closing argument. So first up in the closing arguments was the defense. Then the New York Attorney General gave their closing argument. Before closing argument took place, Donald Trump again tried to delay these proceedings the same way he tried to delay the E. Jean Carroll case. And he said that his mother-in-law's passing was one of the reasons why he wanted a delay, but that hasn't stopped him from holding so-called town halls on Fox and doing a bunch of other things. Donald Trump, through his lawyer, Christopher Kise, said Trump wanted to give the closing argument or part of it, wrote an email to Judge Goron requesting that in New York. You send emails to the judges, but they get docketed eventually on the docket as formal correspondence. And Judge Goron, basically to kind of shorten it, was like, yeah, okay. I have the discretion not to allow it. It's against the law under New York if you are represented by counsel to give your own closing argument. You could fire your lawyers, proceed what's called pro per, and then give your own closing argument. That's fine. But otherwise, here, I have the discretion to decide whether or not you're going to give the closing argument because it's prohibited conduct. But in my discretion, I'll allow Donald Trump to give the closing argument. Just here's the thing. Trump has to just state that he will agree to follow the rules, that he will follow the same rules that you, the lawyers, have to follow, that any litigant in this court. He can't go on random rants attacking the prosecutors, personalities, or saying things about my law clerk. If he sticks to the facts and evidence and gives a normal closing, I'm okay with that happening in my courtroom. Then Donald Trump's lawyers said that's unfair. I don't know why that would be unfair. That's unfair to Donald Trump. He wants to go by his own set of rules. So Judge Goron said that, no, I'm not allowing it. And then Trump and everybody on his legal team whined. They're stopping him from speaking. They're gagging him again. They're not letting him speak, and it's just like, come on. He said you can do it. Just follow the rules that every other American has to follow when they're in a court of law. Then you had the closing arguments take place. Popok, I want to get your thoughts of what went down. But before getting to the Trump part, which I'll throw to you and your overall take, I mean, Alina Habba's argument was, in addition to trying to mock New York Attorney General Letitia James for holding a Starbucks coffee and for the way she was sitting in her chair, which the judge cut off, Habba said, we're all just human beings here. And Donald Trump did his best. Any of the things that the New York Attorney General's office are saying is fraud, that's human error. And he was just trying as hard as he can. That was one of Alina Habba's main argument. She said, explain to me, if you're trying to commit fraud, why would you put the fraud in writing? Why would you send it to other real estate agents as though people don't commit fraud in writing? And then her other point was, why would the Trump organization hire one of the largest accounting firms in the state of New York, Meiselas, which I don't even think they are one of the largest accounting firms, but they're a big accounting firm. Why would they hire one of the largest accounting firms if they were going to commit fraud? Like, okay, Enron hired every big accounting firm. So did Bernie Madoff. People who hire accounting firms still commit fraud. Those were her arguments. And then the New York Attorney General's office was like, you did not hear anything there to rebut the fact that their numbers were wrong. They did not argue ever that they provided correct valuations. What they argued is that based on their own subjective valuation methodology, that they think that their numbers, which are completely off, are correct. But Your Honor, as we've said time and time again, what they neglect is not the valuation methodology. The fraud is the writing. It is the inputs that go into the valuation methodology. So when you lie and commit fraud and say Mar-a-Lago, which is a commercial club, is a residential property and value it as a residential property with no encumbrances on it, that's fraud. When you say your triplex is 30,000 square feet and it's 10,000 square feet, that is a fraud. When you say your buildings are fully leased out, fully occupied at the highest price per square foot, but they are actually rent controlled and they're not fully leased, the input, the data that you put into the valuation model and methodology, no matter which model you use, will be false because it has fraudulent data in it. And when Alina Habba says we're human beings and they just did their best, that is not a defense. And Popok, those are just the cold, hard facts that we have to stick to, right?
Ben, you're being so unreasonable that your case against Donald Trump is based on facts and evidence and not on Starbucks coffee cups and whether the Letitia James kicked off her heels at some point. How dare you? There's a Salty, put back the clip of when the camera's allowed to be in the courtroom for the very beginning. Look at the facial expressions on the lawyers, Chris Keiss to Donald Trump's right, on our left, Alina Habba, that's Cliff Robert on the far end of the table. Chris Keiss looks like he's got a secret. He looks like he's a Cheshire cat, a little Cheshire cat smile. What he knows is at the end of his version of the closing, because they split the closing up and Chris Keiss was the main lawyer, Alina Habba did another part of it, that he was going to, at the end, he was going to ask the judge once again if he could allow Donald Trump to speak. Now, as you noted, and I have one point of clarification, you don't normally email your judge in New York. What happened is that the principal law clerk, Allison Greenberg, doing her job, back to what she actually does for a living, she wrote to the parties right off the holiday and said, okay, let's get back to the scheduling issues. Our courtroom is being used by another case by the New York Attorney General because she can walk and chew gum at the same time, unlike Alina Habba. She's trying the case of the National Rifle Association fraud case in that same courtroom. I don't think it's with Judge Goron, but in the same courtroom. So she's just doing some logistics. Hey, everybody, the courtroom is going to be a little differently arranged. How much time does everybody need? And somebody asked, are we going to do it the old-fashioned way, where the defendant goes first and the plaintiff goes second? We flip it for closing, and who's going to be arguing and that kind of thing. To which the lawyers for the Attorney General, properly responded, we need an hour. It's going to be a split between me and another, special prosecutor, a counsel for this. And then Chris Keiss goes completely, cuckoo crazy down another rabbit hole. He leads, I love when he leads in the email to the principal law clerks before the judge jumps on and says, Happy New Year, Allison. This is the woman, the person who's been mercilessly, misogynistically bashed by Donald Trump, Alina Habba, and Chris Keiss from day one, arguing that she's a co-judge, that she's a hack, a Democratic hack, she's partisan, leading to threat levels going up against her exponentially, people wanting to kill, mutilate her, and worse. Happy New Year. Sure, that's fine, and this and that. And by the way, we want Donald Trump. He literally writes this in his email. And we think Donald Trump he's going to get part of the closing. Like, sorry? Without any citation to any case law that allows that or supports that, because it doesn't. People think, isn't that unusual? Yeah, that's really unusual. That doesn't happen. Okay. He had his chance to speak twice. He only took one of those two opportunities. He got subpoenaed to testify against his interests, cross-examination style, in the case in chief for the New York Attorney General. But then when he had his chance to just get softballs thrown to him by, I would imagine, Alina Habba, to talk about what a great, sexy real estate mogul you are, he passed, as you and I predicted, that he did not show up despite threatening on the campaign trail, I'm going to testify. No, you're not. And you didn't. And that was your opportunity in your case in chief to say what you wanted to say, within limits, under oath. Now, when the issue of Donald Trump came up, then the New York Attorney General jumped in with case law that said you can't do that. Yes, it's in the court's discretion, but the discretion should be not exercised in favor of it. Don't do it, Judge. And if you do it, it's got to be like on very strict orders about what he can and can't do in this courtroom. And the judge also mindful that it's just him. There's no jury present. I think did some things that are unusual that he probably regrets having done. He jumped onto the chain and he said, I have discretion. I think it's important. If he wants to speak and he can do it the right way, this is what I liked about the judge. It just shows that he's no bias. He just wants everything in. He said, I think it could be helpful to the trier of fact, which is me, to hear from the person who's most impacted by my ultimate ruling. So sure, it's unusual, but I'll allow it as long as he plays nice in the sandbox and colors inside the lines and acts like a lawyer. If he acts like a lawyer, maybe not his lawyer, but if he acts like a lawyer, a normal lawyer, he can speak. Now, what I would have done, and I said this on a hot take, is I would have said, and he's under oath, and he needs to be sworn in under oath. A lawyer gets the benefit as an officer of the court to give argument that's considered argument without having to be sworn, but not this guy. So this guy should be under oath. I would have done that. He didn't do that. And instead, they went back and forth in minutes apart about the issue. And Chris Kise, it's unfair. My guy needs to freely speak. He had the opportunity to freely speak about anything wide-ranging. You're gagging him and all the rest. And the judge said, take it or leave it. If he wants to speak, this is it. And I said on the Wednesday podcast with Karen Friedman McNiffalo that was the final word. There was no way he was going to let Donald Trump at the last minute try to give the closing again. But it came up again because at the end, when Chris Kise was done with his kind of walking through why there was no evidence, their major argument, which I've seen 5 times now because they filed four or five different motions to dismiss the case as a directed verdict, directed judgment. Michael Cohen helped us. We win. Yeah. They kept jumping up and down. We've seen these arguments before. They've been rejected time and time again by the judge. The major argument is as mockingly presented by the New York Attorney General in their office. They said their entire defense boils down to Donald Trump's a rich guy and banks like rich guys. And they gave him a lot of money. And they didn't look at any documentation or any representations that he made under oath in lending him money. He just went into a bank and they just sent him to the vault and let him take out all the money that he wanted. That's basically their argument. Ignore that banks at his level of borrowing don't look at statements of financial condition or audited financial statements that were manipulated and cooked by Donald Trump using the outside auditor, but not giving them all the information. I mean, you can cook your books with an auditor, Alina Habba, by not providing the auditor with full and complete access. I mean, every public company that's ever gone down for fraud had an outside auditor, many of which are no longer around anymore, like Meiselas soon, because they got into bed with their client and didn't do their proper control duty to the public. So that whole argument just shows you how juvenile and how they don't understand how business works in America. The fact that, well, he needed outside auditors because banks would not have accepted Alan Weisselberg, who admitted he's not a certified public accountant, but was serving in the role as the chief financial officer just to provide him whatever on the back of an envelope and say, here, banks are funny that way. Underwriting departments in banks making loans are funny that way. They have a little concept called due diligence, and somebody's going to get fired if when they open the file on the audit committee or the loan committee and all they see is a napkin filled out by Alan Weisselberg. there's got to be, like, where is your statement of financial condition? Where is your audited financials? Obviously, they relied on it. There was testimony, as they pointed out in the closing, that Deutsche Bank, the main lender for Donald Trump, required a certain amount of liquidity, cash on hand, by Donald Trump as part of his assets, not just all the real estate money he could actually, without having to fire sale everything, he could actually stroke a check for if he defaulted. And his net worth had to be at a certain level. And that's where the cooking of the books and the pumping up of the numbers came in. And that's the focus. Talk about, to paraphrase Alina Habba, they're not in the real world. They're Trump. They talk about gaslighting. The Trump people are not in the real world. They're not in a business world. They're not in a commercial world. They're not in a banking world. And they're not in a world where evidence and facts matter. And so when the New York Attorney General was putting on their closing, it was reference to all of the testimony, both inside the Trump organization, not just Michael Cohen, others. Alan Weisselberg's statements against his own interests, Trump's own statements against his own interests, where he said, I looked at the statement of financial conditions. I would make comments on them, meaning he put his hands on them, the ones that were used and relied on by the banks with the cooked numbers, statements made by people at different levels of the organization, the flies on the wall in the finance department, in the control department, that Donald Trump couldn't even remember their names during deposition. They killed him in terms of their testimony about conversations they had with Alan Weisselberg and Michael Cohen about pumping up the numbers and cooking the books. And pieces of evidence, thousands of pieces of evidence and documents and handwritten notes by the controller of the company, Jeff McConney, in which he said, DJT told me to do this, pump up this number. Should we be putting this on our financial statements? These are deals that haven't happened yet. Yes or no, in writing, the marginalia, we like to call it, on the side of the document. Right? That's the evidence. So when people hear that Donald Trump lost $500 million, people on our audience, I don't want you to think it's because the judge liked Letitia James or something. It's because he has been the fact finder for the 11 weeks of trial, with Donald Trump having ample opportunity to defend himself. And he came up with nothing more, frankly, than 4 experts who were completely rejected by the judge rightly, because they had no information that would help the judge determine whether fraud had been committed or the level of damage or disgorgement that was in place. They were all hired guns, and I'm being polite. The judge went further and said you can pay a person anything to say anything in dismissing one of the experts. And that left Donald Trump with what? Don Jr. giving a tour of the family history, starting with the Grandpappy Trump running brothels, which apparently is what happened, all the way to Fred Trump leaving $500 million to his son in 1999 to start off his career. So that wasn't helpful to the issues that are at stake. Did Donald Trump use cooked statements of financial condition and use that with counterparties in order to get loans approved, deals approved, transactions approved, tax breaks, insurance breaks? Did he or didn't he? It's binary. And we know where the judge is at because he's already found twice that there's been persistent fraud in the company. Now we're just down to the dust settling and how big of a number for disgorgement. And to correct Chris Kice, it's not damages. He keeps talking about damages in the closing. It drove me nuts. It's disgorgement. It is the ill-gotten money that somebody obtains from doing something fraudulent, where they take the playing field and they tilt it to their advantage, and all that money that comes in their direction, that's what gets ripped away from them and clawed back in a disgorgement proceeding. And that money doesn't go to Letitia James. It goes to the people of the state of New York who have been defrauded by Donald Trump and his ilk in a fraudulent crime spree over the last decade or more.
Think about what Donald Trump's defenses are across all of his cases. So you heard Alina Habba say, if you write it down, it can't be fraud. What was their other argument here? That they had a worthless clause, that you could commit all of this fraud, but if you had a worthless clause, it makes all of your agreements, it makes your word, right? I grew up and my pop said to me, Ben, be a man of your word. That's what I was taught growing up. Be a person of your word. Well, Donald Trump views it, if I have a worthless clause, then my word doesn't matter. I could defraud you, which is, of course, not what the law allows, nor does his disclaimer, which he refers to as a worthless clause, allow any of that conduct. So it can't be in writing. What about if it's oral? What about if you speak it? Well, then he has a First Amendment right, he argues, to say anything, and he can't commit crimes if you engage in speech, according to Donald Trump, because he has an absolute First Amendment right to say anything, he argues. And then when it comes to the 14th Amendment, Section 3 case, disqualification, what does Donald Trump argue? I never even took the oath. I never took the oath to support the United States Constitution. And what does Donald Trump argue about trying to overthrow the results of a free and fair election? I have absolute presidential immunity. I can do whatever I want. So going back to the first thing we talked about, the E. Jean Carroll case, when Donald Trump talked about his proclivity for sexually abusing women, he said that when you're rich and famous, you can do whatever you want to do, and they just let you do it, and you get away with it. Donald Trump has transmuted his abusive behavior as a defense across everything that he does. And as we talk about the cases, these are not arguments that I didn't do it. And that's what the New York Attorney General lawyer said. You didn't hear any evidence that these numbers were accurate. You never heard any evidence that these numbers were the correct numbers. All you heard about was worthless clause, or come on, he just made a mistake. He didn't mean to do it. Or so what? This is what goes down all the time. This is just how rich men do business, which is not the case. And so I think it's important that we frame it and talk about it, how Donald Trump is making excuse after excuse after excuse. And what we talk about on the show and what these prosecutors stand for and what our system stands for is law and order.
There's an example of what we do twice a week on the MeidasTouch Network on a show we call the Legal AF podcast. The title is exactly what you think. That was Ben Meiselas and me. Unpacking, getting down the molecular level, the DNA of the case as we await Judge and Goron's ruling later this month and how big of a check he's going to write in favor of the New York Attorney General against Donald Trump. If you know everything you need to know about Legal AF, I appreciate you. Thanks for being here and being along for the ride. If you have no idea what I'm talking about or what this Legal AF thing is, that was a clip from Legal AF. I am Michael Popok, and until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.